Action on for the people.
Assistant Public Defender Chelsea Vergils. I believe Mr. Davis.
You're just having a rough day, aren't you? Huh? I mean, you come up here twice, you don't have a client.
No,
I'm feeling bad for you.
It's all great. Mr. Davis is.
Oh, your client's here. See, I knew it. I had faith.
Thank you.
I was just stalling for time for him to get up here. All right, go ahead, Ken.
Your Honor, we have provided a plea form.
Yes.
Mr. Davis would like to take the offer to plead guilty to controlled substance use.
All right.
Your Honor, to be clear, that is use of methamphetamine, which does have a different PAC code than use of controlled substance, which we do use in many other pleas. That is MCL 333740428. That's use of methamphetamine, which is a 1-year misdemeanor and or $2,000 fine. Upon successful plea to that, count 1, possession of methamphetamine, 10-year felony, dismissed, no delay, no deferred, no exception.
That's the court's full understanding of the agreement. Is that correct?
Yes, Your Honor.
Let's have him sworn.
Right here. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God? Yes. State your name. Drew Davis.
Sir, it is this court's understanding that you're going to plead guilty to the charge of use of methamphetamine. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Say it again.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights? No. Please look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
and of your own free will.
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of August 6, 2022, at the location of Parkwood Avenue in Ypsilanti Township, Washtenaw County, State of Michigan, did you have methamphetamine in your possession?
Yes.
Did you know you had it?
No, I didn't. Yes. No. No.
Okay, you had methamphetamine in your possession.
Yes. Yes.
Had you used it?
Yes.
Did you know what you were using was a methamphetamine?
Yes.
You did?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Satisfied.
Defense is satisfied.
Court will accept the defendant's plea to guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 13th at 10 a.m. with Judge Washington.
February 13, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you. Court does call the case of the people versus Martin Graham.
Brian Bowling on behalf of Mr. Graham. Just state your name for the record. Your Honor, we're requesting this matter be set for an exam. I believe the discovery to be complete.
People have their witnesses available the 21st. Preliminary examination in person, January 21st, 2025, 9 a.m. before Judge Moore.
Thank you, Your Honor.
Bond continued. Thank you. Court calls case of the people versus Kyle Rainey.
Assistant Public Defender, really, Your Honor, on behalf of Mr. Cal Rainey, who is approaching.
That's what I was looking for. Why? Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
he did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing. To our community.
No, not serious.
Okay. He is, Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to
I
go.
ended up getting a place in Litchfield one day.
Okay. He indicated that he was
You
only
need to take your hands out of your pockets.
He indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield,
Michigan, where I'm from.
in Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved first. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact, and I apologize.
No, you didn't contact everybody you could have contacted. And you didn't get a response. Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else, he was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not, but the issue is, he was on bond for a CCW at the time of this possession case. He leaves the state. And I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And if there are, clearly had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was gonna follow the bond conditions that were set by this court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to community correction. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Everything.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time, the defendants remanded on the warrant. Give me the correction for violation of his bond.
Thank you, Your Honor.
Court calls the case People versus Desiree Radnovich.
Yep, right here.
Okay, hello.
Interrupt Chief on behalf of Mr. Bogdanovich. Judge,
Donovich.
we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have a in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms.
Because she
Bogdanovich,
was-
no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they
I
told
mean,
me.
I've been sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay.
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
All right, so probable cause conference, I'll adjourn it. I have to go 2 weeks out. I would put it 1 week out, but we have to do the whole writ procedure to get you before me. So I'll go to the 23rd, the next date I can possibly do it,
That's fine, Judge.
2025 at 9. Bond in this case will continue,
Thank you.
okay? Thank you, ma'am.
Thank you.
Court call. Court calls the case of People versus Zachary Radcliffe.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people. When you call this one? That's what it's saying, 8:30.
Your Honor, James Thomas, or Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and a $3 million bond was put into place. And at that point, none of
All right, so if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, Your Honor.
But the only thing, I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on?
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
Oof, that's tough. XLB admits to alcohol problems and tether tampering, and the judge shuts down any hope of release until sobriety court weighs in. This is one of those moments that shows how unforgiving the system can be. One slip with the tether, and you're stuck inside. Do you think that's fair accountability, or a trap that makes recovery harder?
I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes,
my staff.
I suggest we set an exam date.
It's not going to happen until discovery is all complete. He's saying discovery's not, I'm not going to do it. What I'm going to do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set him that way. I'm not going to set it. I'm going to hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode protected.
And then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's going to happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where.
What subpoenas?
No, I didn't say that.
Well, is there other notices out there for anything else that you're doing with other than his?
I hear that there is electronic devices that are password protected that is going to take some time to get into, that he may have the passwords to, but I don't think he's going to give them. So we're just going to have to wait on that. That's what I'm here.
Okay.
Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th. First case, People versus Tariq Day. Hey, guys, hold it, folks. Hold on a moment. Who's who is that everybody? I just want to make sure. So anybody with defense counsel that was here, they've left already or they're on their way out? Okay, let them go first. I know I try to alternate, but I probably got it all wrong, folks. I'm sorry, but I just don't want anything. Let them go. And then, folks, if you would be patient, once they've cleared, then those folks can. Thank you. Court does call the case of People versus Tariq Day.
Brian Bowling on behalf of Mr. Day. Mr. Day, are you present? Your Honor, I've called his name numerous times this morning. I was unable to reach him in advance of today.
Bench warrant will issue for defendant's failure to appear, bond set in the amount of 10,000, cash surety. That warrant will issue immediately. Thank you. Court calls case People versus Marcel Steger.
Andrew Children's Attorney on behalf of the people.
Good morning again, Your Honor. May it please the Honorable Court. David Burgess on behalf of Marcel Steger. Your Honor, discovery is complete in this matter. We are requesting exam date. I believe. Go ahead. Sorry.
Steger's co-defendant to Mr. Word, Lee Word, who we called earlier, and we set that for the 21st, I believe, Your Honor.
That's correct, Your Honor.
It was with Judge Moore.
Was it? Okay.
Yeah, that's correct, Your Honor. I was just gonna make sure the date was the same.
All right.